Judicial Appointment Commission Bill 2022 committee stage resumed. We are resuming on Amendment 19 in the name of Senator Barry Ward. I'll read out the groupings again for the benefit of senators and then I'll call on the Minister to speak. If any other senator wishes to speak at this stage, they may indicate to do so. The groupings again are 19 to 28 inclusive or related. 26 is consequential on 19. 19 to 28 inclusive may be discussed together by agreement. Minister, I think. Yeah, on Amendment 19. Yeah.
No, look, apologies, I suppose, for
19 to 28 inclusive and 26.
for not being here last night, but again, appreciate the opportunity to take back up the debate that we left off last week. Specifically in terms of these amendments, so again I want to thank Senator Ward for amendment number 19. This is obviously amending section 13. The Senator's amendment provides for similar matters concerning lay expertise and knowledge in an amended subsection 4. I suppose the version simply provides for a reordering of the 4 criteria. What I would say is that the way they are set out was for no particular reason. I can appreciate why you have set them out and put them in the particular order, but I think for the purpose of potentially having to send it back to the House and do all of that, there's no weight placed on one because it's number 1 above any of the others. So it is just how it has been drafted. So really, it's for those reasons that I won't be supporting the amendment. It's just purely the way it has been drafted. But I appreciate maybe we should have looked at which should have come first or not, or what that might have indicated. Amendment number 22, like 21, 22, 23, 24, 25 were in the names of Senator Higgins and Rowan. Number 20 would add administration, civil society, trade unions to the list of knowledge and expertise to be brought by lay members of the Commission. To take one of these, so trade unions, I would be satisfied that a person that has experience in the worker representation field is not at all precluded under the criteria that's been set out in the bill. A person with public service experience, which is provided for under paragraph A of subsection 4, might well have experience in worker representation. Similarly, with the person who has human resources experience, this is provided for under paragraph B, or indeed a person with experience of the court system or experience of human rights. So I suppose we've tried to keep it broad and inclusive without being too specific, and I think the minute we start getting so specific, you potentially exclude people as well. So that's why we've set out the 4 areas that we have. Amendment number 21 would delete business and finance, but leave public service from the list of matters which are relevant to the section. Again, I think the term business is broad. It would include commercial activity, so that term would comprehend this aspect of the amendment, and I think it would be a positive contribution to the Commission to have a person that would have that type of finance experience or knowledge. Amendment 22 would have the effect of adding as a criteria relevant areas of academic research, including the law or social policy. I suppose we weren't minded to include law or legal references in this provision concerning lay knowledge, because obviously we know that there will be a significant amount of legal knowledge and knowledge of the law, given, I suppose, the composition overall of the Commission and the other members that will fill those other positions. Amendment number 23 would have the effect of adding a criteria concerning the environment, sustainable development and environmental law. Again, I appreciate where the Minister or where the Senator may be coming from on this, considering the fact that we are moving to specific courts and looking at specific areas, but I would ask the question then, would we not have family or other types of law as well? So again, I think just to be so specific, it potentially excludes others, but at the moment somebody who has an environmental or sustainable development background is not precluded from putting themselves forward. So again, it speaks to the point that we really have tried to keep it broad so that nobody is excluded here. Amendment number 24 would have the effect of adding a category relating to international law and international agreements. So another area of the law that the Senator again wants to prescribe, and I suppose it's for the very same reasons that I'm looking to not do that. On amendment number 25, this would change the term protection of human rights to promotion of human rights as one of the criteria. I think it's again, I can see where the Senator is coming from, but I would suggest that what I have proposed and what's been proposed here get to the same point, or that there is the same overall objective. A person can be selected by the Public Appointment Service with experience in human rights and equality, and that is the most important thing here, I think. Amendment number 26 picks up the earlier discussion about the nomination of a Human Rights and Equality Commission, and again, I suppose we spoke about this last week really. While I had considered specifically having a member that would be from IREC. On further consideration, the fact that we're not nominating any other type of body that would have a human rights focus, I suppose it's hard to justify why you would pick one over the other, and I appreciate the significance and the importance of IREC, but there's nothing again to prevent somebody from IREC putting themselves forward, and the very fact that the criteria for the laypersons clearly says somebody with, as I mentioned earlier, human rights background, or someone who would promote or protect human rights. I would fully anticipate that we will have somebody of that standing, and perhaps somebody from IREC put themselves forward and be successful. Amendment 27 would have the effect of no longer requiring the Minister to appoint from among persons nominated by PAS, but allowing discretion in the matter. And I suppose on this, really what we've tried to do, be it the judges themselves having to go through the Commission or the persons on the Commission having to go through the Public Appointment Service, it's to keep it very clear, it's to keep it transparent, and it's to make sure that we have a very visible system and a very coherent system, and that is really the logic we've tried to apply throughout the legislation. In terms of amendment number 28, it would have the effect of replacing part of subtext or text in subsection 5. The existing text provides that the Minister shall appoint lay members from among the persons recommended by PAS. No lay members outside this process can be appointed. The amendment will have the effect of also providing that the Minister can appoint such other lay members as he or she thinks suitable and who has not been recommended. So, as I said, this is why we're trying to keep everything within a specific structure, so that people would all come through PAS, and every individual on the lay side of the Commission, that they would come through PAS. So I think they're all of the amendments. So apologies for missing the discussion the other evening, though. Thank you.
Before I call on any of the senators, could I welcome Mr. Brady to the distinguished visitors gallery, along with the political class from Dundalk Grammar School in County Louth, who are here as guests of Senator John McGahan. You're most welcome. I hope you learn a lot on your day to Leinster House, and you enjoy your visit here. You're seeing democracy in action, and thank you for visiting Shanadair today. Senator Ward, are you coming in? No.
Yeah, just can I, before I move amendment number 19, can I just say I appreciate what the Minister said, and I understand that there may be a concern, given that there have been no amendments made in this House, that if an amendment were to be accepted here, that it would cause the bill to go back to the Dáil. I know the Minister doesn't think that's the only reason why we wouldn't accept amendments, and I understand the rationale behind the decision not to accept number 19, but I hope she might perhaps give it consideration before report stage, and on that basis I'll move the amendment and withdraw it.
By leave the House. Is that agreed? Anyone else on that one? On the grouping?
The one is because it's not actually changing the substance of it, but I appreciate where the amendment is coming from. So,
Senator, any point?
Yeah, speaking on behalf of Senator Higgins and Senator Wan, neither of which can be here today, so I've been tasked with their job, if that's all right. The argument, you know, I understand why things need to be kept, this idea of broad, and when we say things, but it doesn't preclude X, Y and Z from doing it. But I think we've found in reality that doesn't always necessarily translate, you know, in lots of different ways, unless something is prescribed. I find it an interesting argument, and this has come up again and again from different government ministers and different pieces of legislation, which is, well, it doesn't stop someone from doing it. And then we have situations, you know, not to drag it to a different bill, but to use an example where a county councillor applied to be on a HEA, a board of a governing body, and they said, well, we don't have to, there's no reason to put you on it, despite the fact they applied during the regular process, because it isn't in the legislation anymore, even though in theory they weren't precluded from applying. So this idea of you're not precluded from applying means therefore that everyone will. I'm not entirely convinced of that argument. I'm just going to read out, as Senator Higgins has given me, around amendment, we're on 20, to delete section 13(4)(a), which provides that the objective that the lay members will, having regard to the functions of the commissions, amongst them possess knowledge of and experience, qualifications, training or expertise in business, finance and public service. And my understanding from this amendment, it would replace it with a broader provision that among the lay members of the Commission there will be expertise in commerce, finance, administration, public service, civil society or trade unions. and a broader range of expertise being sought amongst the lay membership would be welcome and would go away to ensuring that the Commission is broadly representative of society at large. Amendment 21, deleting the reference to business finance, refers to the expertise in corporate governance, which would cover already the expertise that would seem appropriate for the lay membership of the Commission. And then Amendment 22, and bear with me as I go through these, I gave my commitment I'd do them, would provide that one of the areas for inclusion and relevant expertise sought by the PAS for lay membership of the Commission would be relevant areas of academic research, including the law or social policy, and that this would ensure that there would be a guarantee of academic expertise in relevant areas on the Commission. Amendment 23 provide that one of the areas for inclusion and relevant expertise sought by the PAS for lay membership of the Commission would be the environment, sustainable development, environmental law, and it would be important that there should be appropriate expertise in this area, given that there is a large volume of cases being heard on questions of environmental law and a growing body of case law in this area. And furthermore, there are significant international agreements and domestic legislation in operation in the state, such as the Paris Agreement and the Climate Action and Low Carbon Development Act 2015, and it would be welcome for expertise in such areas to be included as expertise being sought by the PAS. And Amendment 24 would provide that one of the areas for inclusion and relevant expertise sought by the PAS for lay membership of the Commission would be expertise in international law and international agreements or conventions to which the state is a party to. And we feel that this is complementary to previous amendments, which cite specific areas of international law, such as climate or disability law. A broader and therefore a broader range of expertise would be welcome. And then this is to 28. And Amendment 25 would amend Section 13.4d by including the phrase promotion in the language regarding expertise sought for the lay membership protection of human rights. The protection and promotion of human rights are two different but complementary sets of expertise. It would be welcome for both areas of expertise to be included in the lay membership of the Commission.
Thank you. Senator.
The reasons that I've outlined, we've tried to keep it as broad as possible so that if somebody looking at this sees that their area of expertise is not part of it, that they don't feel that they are excluded, that they can't apply, whether it's environmental law. I would argue the case that there's a huge focus and a need to have expertise in the area of family law. So, do we include that in it as well? In terms of business finance and public service, again, I think that covers as broad a range as possible and also covers the specific proposed amendments that have been set out by senators. Again, I think that really applies to all of them. So I think all of the amendments are very much the same, as in just setting out something in a more prescribed way. But really what I've tried to do is just keep it as broad as possible so that it can include as many people as possible and that we're not being specific as to who can or can't be part of the Commission. Thank you.
Senator McDougall.
I just want to say that I agree with the Minister on this, that subsection 4 is not supposed to be a list of wish list of attributes for particular agendas. The purpose is to get reasonably rounded people with a good handle of what they are being asked to do, which is to assist in the recommendatory process to perform that function. And, as the Minister said, there are important areas of law that haven't been mentioned in any of the amendments, such as intellectual property law, family law, land law, all the rest of it. I mean, we can't just cherry pick our favourite aspects of law and say that those are criteria for which justify somebody being selected or not being selected for lay membership of the Commission.
Thank you. Amendment 19. Is the amendment being pressed? Senator Ward, are you withdrawing the amendment?
Withdraw.
Moving withdrawn. Is that agreed? Amendment 20, already discussed with 19. Is the amendment being moved? Amendment being pressed? The question is that the amendment be made. Those in favour say "Tá." Those against say "Níl." I think the amendment is defeated. Amendment 21, already discussed with 19. The amendment being moved? Amendment being pressed? Amendment being pressed. The question is that the amendment be made. Those in favour say "Tá." Those against say "Níl." I think the amendment is defeated. Amendment 22, in the name of Senator Higgins and Ryan, already discussed with 19. Is the amendment being moved? Amendment being pressed. The question is that the amendment be made. Those in favour say "Tá." Those against say "Níl." I think the amendment is defeated. Amendment 23, in the name of Senator Higgins and Ryan, already discussed with 19. Is the amendment being moved? Amendment being pressed. Amendment being pressed. The question is the amendment be made. Those in favour say Tá. Those against say Neil. I think the amendment is defeated. Amendment 24 in the name of Senator Higgins-Ruane, already discussed with 19. Is the amendment being moved? Amendment being pressed. Amendment being pressed. The question is that the amendment be made. Those in favour say Tá. Those against say Neil. I think the amendment is defeated. Amendment 25 in the name of Senator Higgins-Ruane, already discussed with 19. Is the amendment being moved? Amendment being pressed. The question is that the amendment be made. Those in favour say Tá. Those against say Neil. I think the amendment is defeated. Amendment 26 can't be moved, but take note of 27 already. You can't move because it's 19 is consequential on 26, or 26 is consequential on 19. Amendment 27 in name of Senator Ward, already discussed with 19. Amendment be moved? Moved and withdrawn. Is that agreed? Agreed. 28 already discussed with 19. Is the amendment being moved? 28 to inclusive. No.
Move it and withdraw it then.
Move and withdraw. Is that agreed? Agreed. Okay. That's section 13, stand part of the bill. Is that agreed? Agreed. Before I move on to the next section, could I welcome Killusty Tidy Towns, who are here with Senator Garrett Hearn from Tipperary, Leo Darcy and Louise Cohen. You're most welcome. Thanks for all your hard work. And Tidy Towns, my mother's involved in Tidy Towns, so I know a lot of the work that goes into Tidy Towns. Thanks very much for being here today. Section 14, Amendment 29, Senator McDougall, Boyhan, Crockwell, Keoghan and Mullen. A new section already discussed with 2. Is the amendment be moved?
I think it should have been ruled out. It should be ruled out of order at this stage.
Well, if you want me to rule it out of order, we've already discussed it with 2, but we can.
It's the first time I've ever asked for that to be done.
All right. Okay.
I'm not going to move it at this stage. I'll withdraw it with the leave of the House.
Amendment withdrawn by leave of the, is that agreed? Agreed. Okay. Section 50. Section 14, stand part of the bill. Is that agreed? Section 15, Amendment 30 in the name of Senator Ward. Amendment being moved? Or do you want to discuss it? Sorry. Who's gone? Nope. Okay. That section 15 stand part of the bill. Is that agreed? Agreed. Section 16. That section 16 stand part of the bill. Is that agreed? Section 17. That section 17 stand part of the bill. Is that agreed? Agreed. Agreed. Yeah. Section 18. That section 18 stand part of the bill. Is that agreed? Section 19. That section 19 stand part of the bill. Is that agreed? Section 20. That section 20 stand part of the bill. Is that agreed? Section 21. Amendment 31 in the name of Senator Higgins-Ruane. Senator, do you want to move the amendment? Or amendment being pressed? Do you want to speak to it?
I feel like no.
No.
Is she watching? No, I'm good.
Okay. Minister, do you want to comment or do you want me to put the question?
I think really this has just had an extra layer, but already we have, if you look at section 21, it provides that the government may remove a lay member from office on one or more of the specified grounds. We have a requirement for a resolution to be passed by each Houses, so both the Oireachtas and the Seanad, before that's done. So that's an additional safeguard that's already there. So I just think adding the committee on top of that would just be overburdensome, and I'm not sure whether it would be necessary at this stage. So I do think there are, the very fact that it has to go through both Houses, I think it adds that layer there where somebody has to be removed.
Amendment being pressed? Amendment being pressed. The question is that the amendment be made. Those in favour say Tá. Those against say Neil. The question is defeated. That section 21 stand part of the bill. Is that agreed? Section 22. The section 22 stand part of the bill. Is that agreed? Section 23. The section 23 stand part of the bill. Is that agreed? Section 24. The section 24 stand part of the bill. Is that agreed? Section 25. The section 25 stand part of the bill. Is that agreed? Section 26. That section 26 stand part of the bill. Is that agreed? Section 27. That section 27 stand part of the bill. Is that agreed? Section 28. Amendment 32 in the name of Senator Higgins-Ruane. Is amendment being moved? Is amendment being pressed? Amendment being pressed. The question is that the amendment be made. Those in favour say Tá. Minister, do you want to come in?
A few remarks to make. This proposes that we should flesh out in the bill the concept of diversity, and I think it would have very unsatisfactory consequences if it were adopted. I mean, ask the Commission, for instance, to try to work out whether there was adequate diversity in religious opinion, would inevitably, if it was to be a criterion for selection, involve asking people for their religious views to see do they or do they not satisfy that. I don't know what civil status means. I think gender is fairly obvious, or I hope it's fairly obvious. But again, sexual orientation, are we going to have the Commission ask candidates for the judicial office to questions to work out what their sexual orientation is? Their age should be fairly clear to the Commission, but I don't know what the idea of diversity in age is supposed to mean. To be eligible to be a judge, you have to have done 10 or 12 years practice as a lawyer, or the equivalent as a legal academic, with some degree of practice as well. So, I mean, we're not talking about diversity in age. And is it really to be the case? I mean, let's remember a few things about this. We're appointing people to a job which does or does not, and probably most certainly for most applicants would be an important point, involves their pensionability. Are we to say that that people should be, that people shouldn't? There should be a good rash of people in their late 60s because they are well represented in the. I'm not suggesting that somebody in their late 60s shouldn't be eligible, but I don't think it should be a criterion for appointment to say, well, we need people in their late 60s. I really can't see any advantage in this particular amendment, and I think it's pushing unnecessary agendas. I don't want to know particularly, if I was a member of the commission, if I were there, which I'm, of course, prohibited from being, but if I were there, I don't really want to know whether I am being sufficiently diverse in my recommendations by reference to matters such as religious belief, sexual orientation. I don't know what civil status actually means, but these things are really private matters for a candidate for the judiciary and shouldn't be the subject of examination by the Commission.
Rani Hoy.
The Amendment 32 seeks to insert a subsection that adds a clarifying definition of groups to whom the improvement of diversity referred to in the diversity statements of the Commission. It's the Commission's own diversity statements. And I'm quite surprised that the Senator doesn't know what civil status is, considering the groups listed are groups all listed in the Equal Status Act. These aren't randomly plucked out of thin air. This is a list taken directly from the Equal Status Act. And the amendment is simply introduced as a measure for clarification for their own diversity statements by the Commission. So I think if we can't look at Equal Status Act as a guiding principle for diversity and equality, then that's a bit of a pickle, really.
The Equal Status Act is there to protect people from unfair discrimination. And it's to assist people who are discriminated against on those grounds in seeking redress and requiring people to protect them from unfair discrimination. But there's no logical connection between the criteria for unfair discrimination and a process whereby the judiciary are selected by explicit reference to the characteristics mentioned in the Equal Status Act. It seems, I know that my colleague didn't draft this amendment, but I would say that it shows a degree of intellectual confusion if it is based on the proposition that because you can seek protection against discrimination on these grounds, that the Commission should investigate whether you actually do belong to any of these categories before you're appointed.
Ward.
I wanted to agree with Senator McDougall, and the reference to the Equal Status Act, I understand where these terms have come from, but again, the Equal Status Act is there for the purpose of enforcing rights and creates categories in which litigation can be conducted to protect those categories. But broadly speaking, in the context of this amendment, I think it's very important to recognise that, yes, of course, the judiciary should represent diversity to the greatest extent possible, and yes, of course, it should reflect the community as a whole. But that has to be something that is an aspiration rather than an imposition. Because we have to remember two things. Firstly, there is a limited number of judges. The High Court, for example, only has a little over 40 judges. The Court of Appeal has 20 now, I think, or I think it's 20 now, but a small number of people. And you will not always be able to achieve the diversity across these 9 categories that you might want to achieve, because the reality is you may not have enough people to do it. And then the second restriction is on the category of people who are actually qualified to fulfill the positions. So, for example, obviously in certain diversity criteria, such as gender, for example, it is relatively easy to achieve that diversity and that balance, but it may not be in relation to things like ethnicity, membership of the travelling community, disability, age, as mentioned as well. I mean, as a starting point, really, you cannot become a judge in this country if you're under 30. In real terms, by the time you qualify as a lawyer and undertake at least 10 years of practice, you're definitely going to be over 30. So that's one whole category of people who could never be included in a diversity, and the judiciary is never on that basis going to represent people under the age of 30, for example. That is a fact of life. It's not that there is any striving to exclude under 30s from the judiciary, but the reality is that you are not dealing with something where you can simply populate it with the diversity of your choice. The reality is there's a whole range of other criteria that have to come in, and it may well be that of the people who are qualified, there may not be people or enough people who could be chosen to fulfil all of the nine categories that happen to be under the Equal Status Acts. So while I applaud the provision that exists in Section 28 in relation to a statement by the Commission of Diversity, the fact that it is put into the Act that the Commission must be aware of that diversity issue and must therefore strive to achieve diversity where possible, I think we must also remember that the reality of having at least one member of each court, for example, from every one of the 9 categories in the Equal Status Acts is not necessarily achievable. Maybe it will be, but there's a very strong chance that it won't be in every court. And the notion that you would again restrict the ability of the Commission to do its work by putting in such a specific amendment to Section 28, I think, again, fundamentally misunderstands again the role of the Commission, which is to appoint judiciary which must be first and foremost excellent and competent and professional. They've got to be the first criteria, and after that to seek to achieve criteria relating to diversity and representation of the community as a whole and all of that. But first and foremost, we must strive to have a judiciary that can do its job effectively, professionally and excellently, and that's what we must do first. And I don't think that this amendment would help us down that road. In fact, I think that it would substantially restrict the ability of the Commission to do its work. Margaret. Senator, do you want to come back in, or Senator Vincent P. Martin?
The proposed specific amendment is clearly very well intended, and its diversity is clearly required and not reflective on the bench at the moment. However, I'm unconvinced of the such listed detail in a specific statutory provision. I don't believe it's necessary, and it could have an unintended consequence. It could become a distraction. It could become very burdensome, and it's a disproportionate, misplaced, noble aim to insert it in a specific statutory provision as desired in this instance.
Thank you, Senator. And I do, again, I appreciate and I understand perhaps where the Senator is coming from in outlining this, but I would share the same concern as Senator McDowell, where you look at how it's written in this section. References to the improvement of diversity shall be construed to include improvement of representation of persons of classes. I would just ask how you could do that without having to actually ask each individual applicant in the interview process potentially about their sexual orientation, their religious belief or civil status, and I'm not sure that's where we want to be. It's obviously very clearly set out in the law, the Equal Status Act. It's there to protect people where there is a disadvantage against a person because of either one of these particular characteristics. But the very fact that the diversity statement will have to be set out by the Commission within a period of time afterwards, very clearly stating that it should reflect the diversity of the population, but also taking into account, as Senator Ward has said, their competency and all of the other various different factors. So it's for that reason that I'm not going to accept it. I understand the logic behind it, but I think the consequences of the Commission then having to show that people weren't disadvantaged would mean that they would actually have to go through this list and potentially ask people of their status, which I don't think is the intended consequence here. Thanks.
The amendment being pressed? Amendment being pressed. The question is that the amendment be made. Those in favour say Tá. Against say Neil. I think the question is defeated. That section 28 stand part of the bill. Is that agreed? Okay. Section 29. The section 29 stand part of the bill. Is that agreed? Section 30. The section 30 stand part of the bill. Is that agreed? Section 31. The section 31 stand part of the bill. Is that agreed? Section 32, that section 32 stand part of the bill. Is that agreed? Section 33, that section 33 stand part of the bill. Is that agreed? Section 34, that section 34 stand part of the bill. Sorry, section 34, Senator Ward.
Can I just say very briefly, Cathaoirleach, in relation to this section, I think it's a tremendously important recognition of the non-application of the Freedom of Information Act, as I understand it. One of the issues, and it's something that will come up in one of my subsequent amendments, one of the issues around those who may choose to apply for judicial office is the confidentiality of that application. It's tremendously important that that can be maintained, because if it is not, there is a whole raft of people who would certainly be qualified and might make excellent judges who will simply not apply. The reality is that for a person in practice, particularly at the bar, where they are dependent on briefs coming from solicitor, if word gets out that they might be about to be appointed or apply for a position in the judiciary, it can totally compromise their ability to practice. So, and this is an issue that arises in relation to, for example, interviewing people and the extent to which the Commission should or could involve itself in very substantial investigations into that person involving other people. There's a real danger that the information that that person has applied or has put himself or herself forward gets out, and they will totally compromise the ability of the Commission to do its work. So I think in particular section 34 is a very important provision.
Minister, do you want to come in? No? Okay. That section 34 stand part of the bill. Is that agreed? That section 35, that section 35 stand part of the bill. Is that agreed? Section 36, that section 36 stand part of the bill. Is that agreed? Section 37, that section 37 stand part of the bill. Is that agreed? Section 38, that section 38 stand part of the bill. Is that agreed? Section 39. Amendment 33 in the name of Senator McDougall, Boyhan, Crockwell, Keoghan and Mullen. 33 and 36 are related, may be discussed together by agreement. Is that agreed? So 33 and 36 are related and may be discussed together by agreement. Is that agreed? Agreed. Senator McDougall.
These amendments go to the, first of all, I move Amendment 33, and these amendments are intended to go to the heart of what this legislation is in fact saying. And I think it's important that the Minister should give the House some clarity in relation to the purpose of this bill and to its intended purpose. Can the Minister just tell the House at the outset, is it the intention of this bill to make it unlawful or illegal for the government to appoint a person who is eligible for judicial office where that person has not been recommended by the Judicial Appointments Commission?
Simple answer to that is yes. So what we're setting out is a very clear process that irrespective of whether you're a sitting judge or whether you're a solicitor or a barrister applying for the first time, that every individual will come through the same process. Appreciate obviously the Constitution sets out that government will appoint, and that is why I'm not recommending that one name is put forward to the Minister or the government, or indeed three names that are marked 1, 2, 3. I do believe that there should be a discretion. I do believe at the moment, you have a situation where a minister could have up to 60 names. I'm not sure if that's necessarily the best approach either. So while there may be a particular view that the number of 3 limits the government's discretion, I suppose I have looked at this carefully, looking at other jurisdictions and how they themselves put forward names, how they're then presented to government and how they're then appointed, and I think this strikes the right balance. But in short, the answer is yes.
That being the case, it seems to me that the effect of the bill and the effect of non-acceptance of this particular amendment would in fact be to say that the Oireachtas under the Constitution can tell the government that it may not appoint certain people who are eligible to be made judges because they lack a recommendation from a body which is not the government. And you see, the Constitution refers to eligibility as a matter which is determined by law. And I have no problem with the Constitution saying, or sorry, by statute saying that somebody should have 7 years or 10 years or 15 years experience as a lawyer or whatever to be deemed eligible. But we're left with a very strange conundrum here, and that is that if the Attorney General informs the government that 3 people or 4 people who he or she considers to be entirely suitable for instance, promotion from the Court of Appeal to the Supreme Court, have not been recommended by the Commission. Is it being stated seriously that the government cannot make such an appointment? And I go back to this point that as a matter of statute law, as things stand, any judge of the High Court or any judge of the Court of Appeal is ex officio deemed suitable to preside in cases in the Court of Appeal and or the Supreme Court on the invitation of the Chief Justice. So if somebody, if for whatever reason the Chief Justice wants to ask a member of the Court of Appeal to sit as one of the judges in a Supreme Court decision in a court of 3, 5, 7, 9, whatever it is, that person is eligible to do that. But what's being said here is that that person, although eligible to do it and by statute entitled to do it if invited by the Chief Justice or the President of the Court of Appeal, as the case may be, to act on that court, may not be made a member of that court. And the conundrum that I identify here is, if everybody who's a High Court judge is ex officio suitable to be invited by the Chief Justice to serve in the Supreme Court on a one-off basis, how can you say that they are, the government is prohibited from making them a member of the High Court or the Court of Appeal under the Constitution? And it seems to me that what we are doing here is giving a veto to the Judicial Appointments Commission, although we're not admitting that that's what we're doing. We're saying to the Judicial Appointments Commission, you may constantly say that Joe Bloggs or Josephine Bloggs, senior counsellor, senior solicitor, or whatever it is not going to be on the list. And therefore, because you say that about that person, although that person may already be a judge, we are prohibited by statute from making that person a member of a court which they're entitled to serve on in certain circumstances. And I really do doubt the constitutionality of that. Now, I know that the Minister is not going to reveal to us the Attorney General's advice. But on this very fundamental issue, I think that this House is entitled to hear the basis on which the government of the day could actually be prohibited by law from appointing somebody by a concerted decision on the part of a body which is at the moment a 4-4 lay judicial body. In other words, and it really means this, that the judiciary could black somebody from being appointed, even though that person could serve as a judge by reason of their experience and is legally entitled to do so. And it also means that the judiciary could decide that a particular member of the High Court or the Court of Appeal should not be appointed to an appellate body, be it the Court of Appeal or the Supreme Court, as the case might be, on effectively their say-so. And I find that a somewhat repugnant idea, that in effect we are giving a veto to the judiciary about, firstly, who can be appointed to the courts at all, and to a number of judges as to who can be promoted from the Circuit Court to the High Court, or from the High Court to the Court of Appeal, or from either of those courts to the Supreme Court. We're saying that the judiciary can naysay an applicant consistently. And I note that the Attorney General, and we've had a discussion about the Attorney General's role on the last occasion, a very detailed discussion. I note that the Attorney General would be in a position to inform the government. And this is one of the justifications for having the Attorney General on it, I think, that it seems that a majority, a blocking majority in the Judicial Appointments Commission have taken the view that a particular judge should not be a member of the Supreme Court. And they have consistently nominated 3 other people rather than that person, or excluded the person in question from the list of recommended persons for appointment. So this is a fairly fundamental point. Does the Oireachtas, under the Constitution, have the right to tell the government that though somebody is eligible for appointment, they are prohibited as a matter of law from appointing that person? And it's a very, very fundamental issue, because it's a rewriting of the Constitution, in my view. It's saying that heretofore a government has always been accredited with the right to select a judge if that person is eligible. But now they're prohibited from doing so simply because 4 judges constantly say don't. Not by naming the person and saying black mark against them, but constantly putting 3 other people forward and leaving that person on the sidelines. And that is a novel proposition constitutionally. And I do really have a doubt as to whether it's within the capacity of the 2 houses of the Oireachtas to enact a law directing the government to do this. And the Minister has mentioned that there would be a list of 3 and that the government should have a discretion. But why should the government have a discretion? Is that constitutionally required, or is this just a concession to the government from now on that they can choose between 3? Why should the government have such a discretion if it is permissible for these houses to tell them how big the shortlist can be, and whether it can be ordered 1 to 3 or whatever? If those powers are open to the legislature, then it does raise the question, why should the executive under the Constitution have any discretion at all? And it is difficult to justify the democratic discretion that Senator Ward has mentioned on a previous occasion, if you say that it's purely a discretion held by the government on the grace and favour of the two houses of the Oireachtas from now on. And I go back to Senator Ross and his efforts in the Dáil. I'm not talking about Minister Flanagan's legislation, but prior to that, Senator Ross attempted to introduce legislation, the gist of which would have been that a committee of the Dáil, a majority of which was not government deputies, would actually veto or had to approve any member of the Oireachtas. And that, to me, was manifestly unconstitutional. But I don't understand how it is the case that if the government, that the two houses of the Oireachtas can, in effect, say to the government, we'll give you a discretion up to 3. We'll de facto give 4 judges the right to veto any candidate for any judicial office. But you still remain the people who can advise the President under the Constitution as to who should be appointed. And to me, it's a serious issue with this legislation. I don't know whether the President will, in the fullness of time, if this legislation comes before him in this form, ask himself whether he should refer that matter to the Supreme Court and see, is it legitimate, and why is it legitimate that a list of 3 dictated by 4 judges, in effect, is can in effect prohibit the executive from appointing somebody who is otherwise eligible, or from promoting somebody who is otherwise eligible to a particular court. And you know, we're not talking about just people being made district judges on a wet day some afternoon. We're talking about who composes the Supreme Court. And if, say, 6 or 7 members of the High Court and the Court of Appeal indicate an interest in becoming an ordinary judge of the Supreme Court, why is it constitutional for 4 judges to effectively choose between them to start with and knock people off the list as a second consequence, and thereby prohibit those people from being appointed to the Supreme Court? And I've said on previous occasions, but I say it here now, the appointment, as Senator Ward has said, of judges is, in the last analysis, if there is still a discretion, an executive discretion carried out under the Constitution by people elected democratically to serve as the government of the country. But if there is such a discretion, it seems to me that there must be a question mark over whether it is lawful to tell the government that a group of 4 judges have in effect vetoed consistently one member of the judiciary from being appointed to any particular position. I strongly believe that it's not constitutionally permissible to do that. And I just want to, in this context, remind the Minister what's in Section 42. I know we're not discussing that now, but it's hugely important when we consider whether this amendment is or is not permissible. Because Section 42 at subsection 1 says the Minister may request the Commission to make recommendations for appointment or for nomination for appointment to judicial office, as the case may be, where there is A, judicial office standing vacant, or B, he or she reasonably anticipates that there will be a vacancy in a judicial office. Well, If that may really means may, it may also mean may not. If it means shall, if it means that it's obligatory on the Minister to request the Commission to fill such a position, well, I mean, there's two ways of looking at it. It could in effect be shall, unless the government has decided to leave the place, the place vacant completely. In other words, if the government decide there are too many members of the Court of Appeal and Mr. Justice or Ms. Justice Bloggs has retired and we just leave that place vacant, I'm not going to ask for any the Commission to look at the matter. But that's one possible meaning of the word may. But if it is absolutely obligatory for the Minister, wherever there's a vacancy that is intended to be filled, to press the switch for the Judicial Appointments Commission to make a recommendation, then the word may seems to me to be inappropriate in section 42. But my understanding in any event is this, that it would be remarkable, I think Senator Ward mentioned there were 20 members of the Court of Appeal, is that right? It would be remarkable indeed if among those 20 people, 8 consistently sought appointment to the Supreme Court and 4 members of the judiciary consistently vetoed 5 of those 8 by putting forward 3 other persons. That's a remarkable constitutional revolution. And I would like to see what constitutional justification there is for doing this. So I won't put the matter any further than that.
Sorry, Senator Vincent P. Martin, maybe Minister, just before.
Colonel Margaret, this one single amendment is a very substantive one, and it's so central and fundamental. It's like a belt and braces approach to the whole thinking and statutory intention behind the bill. And we'd have the benefit of, if needs be, saving the bill from itself. And perhaps if there is a constitutional challenge at some later date, the legislature should never fear constitutional challenges. That's part and parcel of a robust democratic system. And to look at the statutory intention, maybe these very debates and transcripts could be read into some court record at some later stage. But I think Senator McDougall was almost forcing the government to nail its colours in very blatant terms. And the Minister has replied that it is that is the intention. She's clarified that issue for you beyond any doubt. So then the question goes, so the legislator is prepared to put its head above the parapet. That's what I interpret from today. And then we have to look at, is there enough safety valves in this bill in the way it is drafted? I would construe the may in section, is it 42, as having a different meaning, whereby the Minister is not forced. It's a may. But to accept in full Senator McDougall's well-intended amendment, it's very bold. It's either, if you like, could put the bill entirely at naught. I would have preferred, I think we have to rely on a favourable interpretation of may in section 42 and the doctrine of the presumption of constitutionality of the legislation, that it would never offend or be repugnant to the Constitution. And clearly the Attorney General today has given the government advices, which we're not privy to, that this is just about, I'd say it's very close, but has it done enough to save itself from a potential challenge? And that's another thing about the challenge. And that's for another academic discussion about who would have locus standi to take such a challenge. And how would one ever compile the necessary evidence to show that full members of the judiciary, in a cogent way of evidence, have acted in a certain way. I'd like to think the judiciary wouldn't act in that way, but I'm still alive to the possibility of it's almost like a type of an unconscious bias, where there might be someone who just, you'd want to be really open-minded all the time, every day of the year, to spot a very talented person who may be diametrically opposed to yourself, your views in life, but make a very good judge. And there's a possibility of one of the judges in the powerful position inadvertently going down a road which may not necessarily be fair. But what this amendment would suggest, as I call a very fundamental amendment, it's almost like it's a declaration within the bill that leave the Constitution alone. The Constitution is sacrosanct. Fully get that. A, is it necessary? But B, is it not a given that the Constitution will always trump the legislator? The government of the day should not be fettered by the legislator. And if it is, at some stage there could be a challenge. I'm not sure how that challenge would manifest itself. But our duty is to legislate in a way which is constitutionally safe. I assume, and I'm sure the Minister will give us this assurance, that this has been very well thought out, that there's a safety valve within the discretion of the discretion that allows the legislator to, if you like, I'm not saying they're tying the hands of government, but I think there's a case to be made that they're tying one hand of the government. And if that is so, we are in very uncharted waters. So I'll just have to rely on the expert advice of the Attorney General on a very tricky, constitutionally discrete and volatile issue, and which opens itself up to different interpretations. And I'd like perhaps the Minister should come back in and say, kindly give us some further assurance on that this has been thought out. I think it's novel, and it would be helpful if we saw the advice. I know it's the Chief Advisor to the Government, doesn't have to give a legislator advice, but that would have reassured me, who is not one entirely 100% satisfied that this is constitutionally safe. But I get it. I know where they're coming from. I hope there's enough safety valves and assurances, both in the Act and from the advices, that it would withstand the challenge. But it's a challenge, so be it. And if the President, as Senator said, were to refer to, that's nothing to be afraid of either. That would only help clarify the law for everyone. We should never be afraid of challenges. But it does go. I would be concerned if we adopted this particular amendment. Maybe that'd become the rule and not the exception. And then this is just a dressed-up academic exercise, which means so well. But I'd prefer to rely on the Constitution. I'm not sure if it's entirely necessary to have an act, to have a statutory provision saying, reminding us, by the way, you're not in contravention of an article in the Constitution. But it would have given a massive clarity at the same time. But is that necessary to say that, by the way, we're at all times constitutional here? That's the question. Do we not presume that we are acting in a constitutional way to the best of our ability? And grateful to hear further from the Minister, and even if she wants to think about that, the advices from the Attorney General would reassure some of us as legislators who have this onerous task of deciding on this issue, which is, it's not that simple. Go on, Margaret.
Very much indeed, Senator Martin. Senator Barry Ward, please.
I don't agree with this amendment. I do understand where Senator McDougall is coming from, but I feel that he has created a very forced scenario, which he has reinforced by suggesting that there will somehow be this judicial veto. I don't think that's the case, which is why, Minister, in fairness to you, I think you have strived to have a small commission with a balance between judicial and lay figures. And what Senator McDougall is trying to put together, and not in an unmischievous way, because when he was Attorney General, certainly wouldn't have thanked